You touched on guilty pleas and how a lot of the people who were convicted of criminal offenses involving HIV was because of pleas. Do you think that a lot of these pleas were because they didn't know what their rights were, or they were encouraged to do so by counsel? Do you think they were properly informed of what was going on before they made those pleas?
Yes, that is the case, I think, for a good number of the cases, that people didn't fully appreciate what kinds of arguments might be made in their defense. In some cases, they had defense counsel who were not particularly well versed in some of the science of HIV, and so perhaps were not even contemplating the kinds of arguments that they might be able to make. I think another factor in a number of cases, certainly some of those where I've spoken at some length to those who were facing criminal charges, is that in some cases people were being held in custody pending trial, for example, and at a certain point that really wears you down, and so you just want it to be over. And so I know of some cases in which people have pled guilty, sometimes to reduce charges or to a reduced number of charges, even if they might have had a fairly good legal argument to advance, because they just wanted to get out.
It's unfortunate because you hear of a lot of people sometimes who would plead guilty when they might not even be guilty at all. They just want the charges to go away. And they're offered this false sense of, well, if you plead guilty to this, we'll give you something called a conditional discharge, where in 3 years these charges go away. They don't actually go away. There are still systems, and there's still media coverage, and there's still things around you that you're technically considered guilty of this offense. You've been convicted of the offense. And it's just sad to hear it, and I hear it all the time. So that's why I wanted to pose the question.
Yeah, one of the barometers of success is, in fact, maybe a reduction in guilty pleas, right? You know, if the criminal lawyers that have come on board and have really been doing excellent work continue to do that, we would expect that that would continue to be the case, that there would be less and less people pleading without, you know, going to trial.
The discourse around human rights on the criminalization of HIV transmission was vague. In one of your notes, could you clarify on that?
Certainly, in terms of the debate that we're having as advocates is how much we focus on the human rights violations that have occurred with inappropriate prosecutions and inappropriate police investigations, compared to the arguments that we have public health impact. And it's an ongoing discussion. So in the United States, for example, the Positive Justice Project believes that they can engage, because they have HIV-specific laws, they need to engage with lawmakers, with Congress, and they believe that focusing on the public health, the bad public health impact of criminalization might change policy in the United States. But I think we have to remember that really what criminalization is doing around the world is cherry-picking a few individuals living with HIV and blaming them for a collective failure in terms of HIV prevention. And that there is a huge amount of injustice in these selective prosecutions. And so obviously the human rights arguments are very strong too, but it's just I think we have to be smart about using the right arguments at the right time in order to limit the law.
Well, to begin with, as a comment, historically illnesses have been managed in such a way that it's through exclusion, segregation, and this time, or in this era, is being managed through criminalization. So it's quite interesting to see how we socially do things. So through the maps, I was very, very impressed about the maps that you were showing, because internationally there are some countries that are criminalizing HIV, and some other countries are prosecuting HIV cases. However, some countries are not doing that. How come? I'm thinking what they are doing, they are not criminalizing HIV, and some countries that are, or some regions of the world that are so-called progressive, like Europe and North America, for example, are criminalizing this illness, but other countries are not doing that. I'm wondering about that. Maybe that would be a good way to begin to talk with other ASOs from countries that are not criminalizing HIV, to see how they are doing, how they are addressing their campaigns, because in other countries that the criminalization is happening, so maybe we are not doing something right.
There is some good practice that we can learn from. So in South Africa, for example, they looked at the issue of an HIV-specific law from about 1999, and there was a 2-year period where experts on HIV in the law got together and they had a consultation, and they decided that there were far more many reasons not to have an HIV-specific criminal law, primarily for the benefit of public health, but also because they felt that the general law could be used for egregious cases. And the same happened in Mauritius. Often it's a combination of really smart civil society advocates informing and educating lawmakers. Latin America has actually a very good history of human rights advocacy within civil society, and the HIV sector is gaining from that. So there are I don't believe there are actually any HIV-specific laws in Latin America, and there have been very, very few prosecutions, and only use like 1 or 2 using the general law. The problem is that in Canada you've got the Perrier decision, and it's hard to know how you've gone through your policy options, the 3 policy options, and I think that the only way forward here is through prosecutorial and then police guidelines. I'm not sure what lessons Canada can really learn. You could have, in the past, before Perrier, possibly. But right now, I think that actually I think it's really important that the United Nations recommends that there should be no HIV-specific laws anyway. But there isn't that there aren't good HIV-specific laws because they stigmatize. They're about singling out HIV above any other transmissible disease. So I'm not sure that's a good option either.
And there are many other strategies that we need to consider in trying to address the issue. For example, it would be really nice to see some HIV prevention campaigns that remind members of high seroprevalence communities that preventing HIV transmission is a mutual responsibility. One of the things we're facing is the shift in norms of conduct, particularly I'm concerned in MSM communities, where men who are exposed to HIV and their sex may now start to think that what they should be doing is going to the police. Right? And so there's been an increase in gay men, in charges involving gay men. So it would be very nice to sort of start to try to intervene in that kind of process of norms of conduct and expectations, so that we can move back to traditions of mutual responsibility in HIV prevention. It would be nice to see, some public campaigns from our AIDS service organizations discouraging people from, thinking that the first thing that they should do if they, realize that they're exposed to HIV sexual encounters is now to the police. It's just not a useful sort of strategy or approach. So I think there's other things that can complement the kind of legalistic kind of stuff that we're talking about tonight that are things that we need to consider and start to think about.
Okay. I had a brainwave of one other thing when you're talking to prosecutors too, is that witnesses are always supposed to be cautioned that if they make any kind of false statement when they're speaking to the police the first time, that itself is a criminal offense. And I've rarely seen witnesses who lie about stuff actually get prosecuted. I'm not a big advocate of prosecuting people for all kinds of things, but when people lie about stuff, they should know that as they were warned when they went to the police and made the complaint in the first place, if it turns out that there's evidence that they lied, they should feel that sting, because the person who is accused, and that's something that's already there in the criminal code, so prosecutors could and should use that.